I think the Supreme Court has to be, sober, or has to exercise sobriety while referring to conduct of persons. Sobriety, I think, has also been mentioned in Zakia's judgment. I think in every case, the court has to, be a little careful.
So, when a statement of this kind is made, what kind of inference can be drawn from the top court's use of the term need to be in the dock? If the Supreme Court wanted to initiate action against some people, would they not have just issued notice to them?
Yes, you're right. If the intention of the Supreme Court was that action should be taken against these people, including Teesta, they should have, or they could have issued notice to them and said that, you have abused the process of law, and we propose to take action against you. But you see, the Supreme Court is not a prosecutor in that sense. You see, they can take action against a person for contempt of court, right? So, abuse of the process of law in a situation like this does not amount to contempt of court. So, even if the Supreme Court had issued notice, what could it have done? It wouldn't have said that, listen, we think that a case should be filed against you, so therefore we direct the state of Gujarat, or we direct somebody to file a case against you. That's not the job of the Supreme Court.
The kind of language that the Supreme Court employs in the Zakia Jafri case is sort of unprecedented. And is the way that it provides the basis for targeting of those who have brought a case to the court in the first place, is it likely to have a chilling effect on others who seek accountability?
Yes, it will have a chilling effect, certainly, because the impression, that people can get, and certainly the Gujarat police got that impression, is that, if you support a person who you think has done something wrong in the form of a criminal offense, for example, if you support that person, well, you're also going to be in trouble. Okay, so you will have instances where a person has committed a crime. It could be a serious, heinous crime. And that person, takes the assistance of somebody else, not necessarily a lawyer, but somebody else to do the, legwork and assistance and so on, and briefing the lawyer. Then that third person can, be in trouble, possibly. Okay, so that person will be a little careful and say that, listen, why should I get involved? It's your problem. You sort it out with your lawyer. Don't involve me in it. So it can certainly have a chilling effect.
So, but I mean, looking at the chain of events, Teesta Setalvad and R.B. Srikumar were arrested within 24 hours of the Supreme Court judgment. And the FIR was based on a complaint that cites the apex court's judgment. But also, this isn't the first such judgment in which a constitutional court has gone on to make far-reaching aspersions about the hidden conspiracies. Like even in the hijab case, the Karnataka High Court had said that that the way the issue has unfolded, it gives scope for the argument that some unseen hands are at work to engineer social unrest. Is this, I mean, given all this, have we reached a point where there is a need for our courts to cautiously word their orders, their judgments?
Yes, and the courts have to always. I mean, it's not only in this case or in any other case. I think in every case the court has to be a little careful, and sobriety, I think, has also been mentioned in Zakia's judgment. That's what my impression is. But even if it is not, I think the Supreme Court has to be sober, or has to exercise sobriety while referring to conduct of persons.
So, in a more general sense, journalists, activists, human rights defenders, they're being caught up in a bizarre array of cases. Like from the arrest of Teesta Setalvad post the Zakia Jafri judgment to the arrest and remand of fact checker journalist Mohammad Zubair for a satirical tweet that he had made in 2018, borrowing a scene from an old Hindi film that is still not been banned. Like that film is still being played and replayed on television as per reports. And the arbitrary arrest of journalists in Kashmir. Is the judiciary somehow consciously or unconsciously allowing this to happen? Is there a way, and if they are, is there a way that they can stop this? What kind of proactive steps should the judiciary be taking in light of arbitrary arrests?
Well, I don't think the Supreme Court is consciously doing this. I don't think the Supreme Court is even intending this, right? But it's the use of this, unfortunate language, which has given rise to this feeling. Okay, and well, if the police, say that, oh, we are going to take advantage of this, you are abusing the process of law. It does not even require a judgment of the court to say that, because they can then say that, oh, you see, in that Zakia Jafri's case, the Supreme Court said that these kind of persons should be put in the dock, right? So we think that you have, abused the process of law, and therefore we think that you should be prosecuted. So yeah, it will have an impact on journalists as well, because if a journalist goes on to investigate a particular crime or something, they'll say, oh, why are you doing this?
I mean, is there a way that the courts can kind of help?
A general order has been passed, guidelines have been laid down in the case of Basu, DK Basu. Guidelines have been laid down in the case of Arnesh Kumar. What more can the Supreme Court do? They can't go to every police station and say that, listen, are you doing something illegal? Are you doing something arbitrary? It's not possible. So the Supreme Court has, issued guidelines on how to arrest, when to arrest, But if the police does not adhere to those guidelines, then the only thing that can be done is the magistrate before whom the person is produced should take it up and say, what are you doing? You're violating guidelines given by the Supreme Court, and therefore I hold that the arrest is illegal, or that the person should be granted bail.